Federal judge blocks new labor rule for migrant farm workers in 17 states.
This is Dr. David Shine, and welcome to Business Law 101.
In an important case for agricultural businesses in the U.S., a judge has blocked a Department of Labor rule that would have given temporary migrant farm workers rights to engage in concerted activities and other protected conduct that comes under the National Labor Relations Act, NLRA, historically does not cover these temporary agricultural workers. This illegal action by the Department of Labor was in a final rule issued in April of this year. The Department of Labor argued that agricultural businesses are not playing by the rules, which require terms and conditions of these temporary migrant workers to be equivalent to domestic workers. The concern being that employers may take advantage of them, thereby hurting the opportunities for domestic workers. So the approach was to give these migrant workers the chance to bring complaints and be protected under the National Labor Relations Act like domestic workers. In turn, a coalition of 17 states, including Kansas, Georgia, and South Carolina, the Georgia Fruit and Vegetable Growers Association, and Miles Berry Farm of Georgia, sued in federal court to block the application of the DOL rule. They claimed that it violated the wording of the National Labor Relations Act, that such workers are not protected under the act. U.S. Judge Lisa Godby Wood ruled in favor of the plaintiffs and issued a preliminary injunction to block the regulation from going into effect. She stated, and I quote, "By implementing the final rule, the DOL has exceeded the general authority constitutionally afforded to agencies." She also found that the plaintiffs could, quote, "suffer irreparable financial harm if the rule was enforced." The judge provided some additional strong language about DOL's attempt to implement this rule, holding that Congress did not intend to give farm laborers the right to participate in concerted activity to further their interests, and added the DOL may assist Congress, but may not become Congress. Some powerful language there. This is part of a recent trend to rein in the power of administrative agencies. Therefore, if DOL appeals this up the ladder, I do expect that SCOTUS will uphold this ruling. Most of the agricultural states that use migrant workers, other than California, New Mexico, and Arizona, were covered by this court's ruling. This is Dr. David D. Shine for Business Law 101. If you've enjoyed this episode, please subscribe on your favorite platform.